Yes, please.
Item number 1.
My lords, this miscellaneous applications, my lord, has been filed, my lord, to a very limited extent, my lord. My lord may kindly have page 5, paragraph 3 of the application, my lord.
Who has made this application?
I'm sorry, my lord.
Who has made this application?
My lord, this application has been made by the Association of the Hawkers, my lord, a registered association, my lord.
They are representing vested interest, my lord. They are preventing us from doing the lawful job.
I'm sorry, my lord. Let me complete, my lord. Vesting interest or not vesting interest, my lord. I don't understand why when it comes to the hawkers, my lord, why they want to bulldoze and arm twist this downtrodden people, my lord. My lord, kindly come to paragraph 3, my lord. Paragraph 3. The restricted vending hours 12:30 p.m. to 2 p.m. and 7:30 p.m. to 9 p.m. have rendered hawking commercially unviable. The absence of meaningful consultation prior to fixation of such timings and absence of proper vending zones or infrastructure directly contravenes section 3, 4, 5, 10, 12 of and amounts to indirect evictions, my lord. My lord, while we have my lord here now what happened, my lord, here the process is still ongoing process, my lord. We bow down to my lord. My lord has given a time zone, my lord, to vend for those who have got COP.
So that you are not 100% deprived of your business. You see, you are licensed, it is all right.
Yes.
But
yes.
you are not permitted to hawk or vend.
Yes. That is
encroaching the street.
My lord, we bow down to
Right.
that, my lord.
Street vending is not allowed.
Yes.
Some vending zones have been allocated by the government, which are being allotted to you
My lord.
to vend.
My lord.
This is taking some time.
Yes.
So
yes.
in that intervening period,
Yes.
would you be deprived of business and income? Zero. So the court tried to give you some
Yes.
some kind of a leverage.
Yes, my lord. My lord, we bow down to that, my lord. So therefore, in furtherance to my lord's good intentions for the livelihoods of poor, we come once again, my lord, with all humility and humbleness, my lord, saying that, my lord, now it takes us, my lord, 1 hour to set up our shop, 1 hour to, my lord, dismantle our shop, my lord. So what happens, my lord? We have got just hardly 1 hour of vending there, my lord. 1.5 hours of vending, my lord. So this is really taking a toll in the intervening period, my lord. So what we were requesting, my lord, is that kindly relax us little bit of time, my lord. We are fully cooperating with the Provisional Town Vending Committee. We are fully
Mr.
cooperating.
Advocate General, how much time it will take to allocate?
We have already allocated, my lord. By 22nd July, we are doing it. The grievance is not this, my lord. What they are coming for your lordship. If your lordship will see just see 2-3 pages of my status report, which I filed on 1st July, my lord. And their grievance is at paragraph 6, my lord. Kindly see at their application. Application paragraph, page 6, paragraph 6, my lord. In the garb of this, my lord, they have got key proposal in the representation as pedestrianization of Hindai lad to lad so and so. So they want entire road to be make pedestrian, my lord. And we have, my lord, if your lordship will see, we have taken care of their interest and we have examined each and every aspect, my lord. Kindly see my status report, my lord. That page 27. Because meeting after meeting we are holding with them to streamline everything, my lord. Page 25 of my status report filed, which is dated 1st July 2025.
It's not a
If your lordship will kindly come to page 29. Page is at the bottom, my lord. Whatever their demand was, my lord, we accepted it. Page 29. It is the vending zone, because the issue before your lordship is relating to Police Bazaar, my lord. And it is a vending zone which we have created, and layout plan was given to them, first floor of Mudda parking lot at Police Bazaar, Shillong, my lord. Page 29. And then we are also giving them wooden stall, my lord. If your lordship will see page 30, 31, 32 and 33, my lord. This is how we are going to accommodate them by 22nd July, my lord.
Wooden stall where?
In the, if your lordship has noticed, there is a Marba hub and there is a parking lot on this main road only. So there is a building, and they came to us that earlier location was different. They said that you give us the different location, my lord. If your lordship will see the discussion between the parties, my lord, at page 41. Page 41, where we have taken note of everything, my lord. Page 41, this is 16th June.
This is on the footpath.
This is inside, it is inside, my lord, inside the building, just next to the Police Bazaar main road.
This building?
Yes, my lord.
Mudda parking lot?
Yes, my lord. Entire part.
This is part of the space which we have colored in black.
Yes, my lord. And if your lordship will see my map also at page 37, bottom. The red lines are no vending zone. Green ones are vending zone, my lord. And here your lordship will find at Bhajan Lal and the Mudda, this is the building where we are accommodating all the vendors who have received the certificate of vending, COV, my lord. And that your lordship will find the distribution of certificate of vending at page 39, my lord. We have identified, my lord, one sec. Garment is 134 vending, footwear, and that way we have total certificate of vending of 221, my lord. Now after that there was a boycott, etc., and a representation was submitted to the town vending committee, my lord, and town vending committee has considered each and every submission, my lord. Kindly see page 41. Your lordship, kindly see small Roman 2 at the bottom of page 41. Lordship has page 41 bottom, disagreement to relocate to designated vending zones. Your statement that vendors of your organization have not agreed to move anywhere else, including SMB, Shillong Municipal Board parking lot opposite to SBI. In this regard, it may be pointed out, government had declared following places as vending zone wide notification dated 17 December 24. Zone 1, Muda Complex, frontage 56 stall. Zone 2, Muda parking lot, 230 stalls. Zone 3, SMB parking lot opposite SBI, 66 stalls. However, ground floor of Muda parking lot was denotified by 2nd May. Instead, first floor, because there was an objection, first floor was notified in place. Committee noted that change in the said location was effected as per request of the Street Hawker Association and was agreed upon by association. Hence, this issue does not arise, my lord. So we have given them, we heard them, my lord. Now, second issue is that genuine distribution of certificate of vending, my lord, who are not genuine. The association objected to distribution of certificate of vending to the surveyed eligible hawkers by alleging that persons who are not genuine hawkers and who have also sought have been submit the papers to the process of certificate of vending can be considered by. Committee did not accept the complaint and certificate of vending was processed based on the provision of the street vendor scheme. A proper digital survey was conducted. Documents submitted during survey were duly scrutinized as per minutes of 11th meeting of Provisional Town Vending Committee on 14th February. Committee decided to give opportunity to all hawkers to submit their claim and objection on surveyed vendors, and number of claims and objections were submitted by Meghalaya and Greater Sinod so and so, Meghalaya so and street 41 vendors, my lord. So they, everything, my lord, meticulously it was done, my lord. Since due process was adhered by TVC during the hearing, claims and objections, even members of Meghalaya Greater so and so, and part of hearing, as such their objection held no ground, my lord, because there will be some issues time. Now, my lord, last one. The design and plan for construction of stall was initially proposed to be taken up by the Urban Affairs Department. However, Ms. Srimati Angela Rangad, a TVC member, my lord, the representative of the applicant, my lord, representing your association, had requested for permission to prepare and present a detailed plan and estimate for the proposed staff by engaging your own architect. TVC had agreed to the proposal and allowed her to present the presentation of the plan and estimate during the TVC meeting held on 14th May. But during the presentation, only a general idea concept was presented without a proper plan, design estimate, since Srimati Angela Rangad had requested additional time of 15. Finalized detailed plan estimate is duly accepted, but till date detailed plan etc. is not there, my lord. So we have done whatever is required under the law. We have given them a space. We have accommodated that, my lord, and hearing was held, and after that all the proceedings have been done, my lord. Now every time now because they do not want to vacate the main road. That's a difficulty, my lord, and they are trying to take shelter of these applications after application. Rather, if your lordship will see, lordship's order, last order, is very clear that they will give undertaking, my lord. The lordships have said in the last order that they will give undertaking and cooperate in vacating the main streets, and they are not even they have not given undertaking despite your lordship's order. If your lordship will see, your lordship's order, it says that General Secretary of Association also undertakes to this court shall ensure that as and when alternative vending place is provided by local authority to any vendor, he will immediately shift. If he does not, then he shall be liable for evicted from the place of vending, my lord. So we are facing problem, my lord, because they are not cooperating and they are vested interest who are taking shelter of association in sabotaging the entire orders, and your lordship has been monitoring this PIL since beginning, and your lordship has been pushing and cajoling the state government to do the job. But there will be some issues here, and we are addressing. We are meeting them, we are discussing with them, and we are addressing all these issues, my lord.
Lord, there is no compliance with the last order also, my lord.
What is my applications before my lord, my lord? Whatever learned the Advocate General has read out, my lord, it is on the minutes of the meeting and so on so. And my lord will see that the association has already raised an objection, my lord, which was read out in the minutes of the meeting also. Why are you giving COV vending licenses to people who already have a shop? This COV is completely meant, even my lord, our members, our association member were two licenses were given. One we have given up because one family requires only one licenses. So this is not even themselves also in the meeting. They've said that they have not adhered to, they have not accepted our objections. Themselves also they've said just now. And now because of which, my lord, kindly paragraph 8 of my application, I'll just read out paragraph 8 of my applications.
This will tell it. Like they give an examination paper to read the question.
So paragraph 8, my lord, I was just referring to paragraph 8.
You please listen to this. This is an ad interim order.
My lord, my lord, my lord.
We have heard learned counsel for the parties. In this application by the Hawkers Association, in this application by Shillong Roadside Hawkers Association.
Meghalaya and Greater Shillong Progressive Hawkers and Street Vendors Association, my lord. The name is.
Okay.
Yeah.
Comma. Principally, the regulation of the vending hours fixed by our judgment and order dated 3rd July 2025 is sought. Full stop. The ground is that such restricted vending hour is not serving the purpose for which it was granted, comma, to ensure some business to the licensed street vendors till in Police Bazar till they were shifted by the government to the allocated vending areas. The vending hours as restricted were 12:30 p.m. to 2 p.m. and 7:30 p.m. to 9 p.m. Mr. Yobin, learned advocate for the petitioner, submits that some time is taken in setting up shop and in dismantling it. Full stop. Everything within this restricted time is causing hardship to the vendors. Paragraph. On the other hand, learned Advocate General has very emphatically tried to impress upon this court that some, within quotation, vested interests, unquote, are involved behind this application. Full stop. The government has taken all measures to ensure that these vendors are relocated by 22nd July. He showed us the notification dated 2nd May 2025 and the layouts, plans and drawings appended thereto. Full stop. He said that these vendors in Police Bazaar were being located in a building at the MUDA, MUDA parking lot in Police Bazaar.
Three places, my lord. If your lordship will see PS 23, my lord. PS 23. If your lordship will see location, this is Police Bazaar, Khindai Lad. Muda complex frontage. His area is 75 square. Number installed is 56, my lord. So Muda complex frontage 56, my lord.
Yes.
And Muda parking lot, first floor now is, they have said they don't want to
This
go
is
to.
all. This is all police bazaar area.
Yes,
Kundai.
police bazaar area. my lord. This is
Okay.
a dispute before your lordship today is in respect of police
what-
bazaar area only.
What have you written? No, it have been relocated in 3 places, namely Muda complex frontage, comma, the Muda parking lot basement,
Not basement, front, first,
and the Shillong Municipal Board parking lot
first floor. Sir.
opposite State Bank of India.
Yes, my lord.
Full stop.
Basement, my lord, later on has been changed to first floor.
First floor, my lord. Your lordship will find at page 41 because they said that they wanted not basement, first floor, page 41.
Okay. Muda complex first frontage
Yes, my lord.
and Muda complex first floor.
Yes.
Yes, parking lot first floor, ma'am.
Muda parking lot first floor.
Yes, my lord.
And that such rehabilitation would be completed by 22nd July.
22nd July.
Yes. Paragraph. Having considered these rival submissions, we modify our order dated 3rd July 2025 by granting by granting an additional time of half an hour during the additional time of half an hour and 15 minutes in the afternoon vending hours to lay out the shop and to pack up respectively, and similar extension of time in the evening vending hours. Full stop. In other words, the vendors will be allowed to start setting up shop from 12 noon and to start packing up from 2 p.m. till 2:15 p.m. and again to start setting up shop from 7 p.m. and to pack up by 9:15 p.m. Full stop. This will be done under the strict supervision of the public authorities and the special officer. Full stop. During these hours, the Traffic Department will be extra cautious by deployment of additional police personnel to regulate traffic in the area. Full stop. In case, next slide, in case the allocation cannot be effected by 22nd July, the petitioner shall have liberty to apply. Shall have the liberty to mention this application for further orders. No, all right. You cut this line out. This application is made returnable on
The main matter is coming on 5th August, my lord.
on 28th July. Let us see whether they can allocate.
My lord.
The applicant should adhere to the timing, my lord. There is no compliance to the order of the court, my lord.
That
They are not adhering to the timing which has been given by the court, my lord.
The authorities are there, special officer is there.
special officer is looking, my lord, at. My lord. Obliged.
Shall we go on a horseback and in police bazaar?
Number 2.
Yes, please.
Please, my lords. My lords, as per the last order, lordships, order dated 15th 5/2025, lordships was pleased to direct the state respondents to form these district
Monitoring committee has been formed, Your Lordship, in the different districts, and we have submitted a report to that effect, Your Lordship.
Lordship, we've
With all
received,
the annexures with a copy to the other side. Also.
we received it yesterday, lordship.
What do you want to do? You want to go through it?
Lordship, I'd like some time to examine the same, lordship.
Steps were also taken, Your Lordship, to issue notice to the district council, Your Lordship, whom we are not representing, but we took steps as per Your Lordship's order dated 15/5/2025.
Yes, please take on. paragraph 1 of the order dated 15th May. Initially, the scope of the writ was confined to the area under the jurisdiction of the Shillong Municipal Board, also by our order dated 15th May 2025. It was extended to cover the whole of Meghalaya. Full stop. By this order, the court directed activation of action under the Animal Birth Control within bracket dogs Rules 2001, framed under subsection 1 of section 38 of the Prevention of Cruelty to Animals Act 1960. Mrs. Yangi, Learned Additional Advocate General, has today filed a report dated 15th July 2025. In the form of an affidavit. Affirmed by the Secretary to the Animal Husbandry and Veterinary Department, Government of Meghalaya. Full stop. She submits that there has been full compliance with the order passed by this court. The said report is taken on record. Learned advocate for the petitioner wants to peruse the report. Full stop. Such leave is granted to her. List is public interest litigation for further directions. On 22nd July.
22nd. Wait for lordships.
Number 3.
May please stop. This matter is pending before the Supreme Court also. We have filed an appeal against this honorable court order, Lordship.
But in this case, your Lordship has directed impleadment of Ilaka head, my Lord, and that order was challenged by the petitioner before the Honorable Supreme Court. The notice has been issued and matter has been pending, but as such there is
So
no...
then why this appeal?
Because against in this appeal only, my Lord, application was filed by state to implead the headman of the Ilaka because it is relating to receipt of land compensation. So the individual owners are resisting.
From a From an interim order, they preferred an appeal.
The interim order they have preferred and matter is pending before Honorable Supreme Court.
Yes, Lordship.
So can the main appeal be held up for that?
And that
Yes, sir.
in my
Notice has
submission,
been
matter
issued.
can be heard and decided, my lord. And there is no stay on the impleadment of the headman also. That order has, they are not complied also.
But that matter is pending before Supreme Court, Lordship.
So what?
So, Lordship, we
We will see whether it will have any repercussion on the outcome of the main appeal.
no, the outcome of that appeal will have a bearing on this because it's
The learned advocate general does not think so.
Lordship. What happened, Lordship? We have filed an appeal. We have filed an appeal against the learned single bench order, Lordship, in which, Lordship, throughout the proceedings, they have never filed any application to implead those strangers, Lordship, two strangers,
So
Lordship.
that has been dismissed.
So, Lordship,
That has
when
been
we
allowed,
file an
Lord.
appeal, and in appeal they come up with an application seeking to implead those two parties, Lordship. So, an order was passed, Lordship, and against that order we challenged. We filed an SLP before the
When?
Supreme Court, Lordship.
When?
Lordship, that is in 2023, Lordship.
26th April 2024, my lord.
20.
Notice was issued on a stay as well as SLP, my lord.
Sorry, Lordship. In 2024, Lordship, we have filed.
26th April 2024.
And yes, Lordship, it's still pending, Lordship. It's arising out of this writ appeal, Lordship.
An appeal from an interim order. SLP is pending.
SLP is
SLP.
pending, Lordship.
A special leave petition from an interim order in this appeal is pending before the Supreme Court as submitted by learned counsel for the appellants. Full stop. He says that during such pendency, this appeal should not be taken up. Learned Advocate General, appearing for the respondent, submits that this petition is pending from 2023 before the Supreme Court.
24, Lordship.
24.
24. Stop. The appellants have not been able to obtain any stay of this appeal. Paragraph. We adjourn this appeal till 4th August,
Lordship, the Supreme Court matter, Lordship, it will come up
when we shall examine whether we should take up hearing of the appeal or not. Let it appear in the list. Learned Advocate General, please assist us.
of Lordship.
Number 4.
Five and six are different matters. Just call five. Just call five.
Number 5.
Please, Your Lordship. Lordship, yesterday I stopped at the point of page.
Inculpatory and exculpatory remarks.
Lordship, yes.
Yes.
So, from fortifying 164, so we have come now straight to what is 164 statement, which is at page 35.
Yes.
There are two components very important, Lordship, in this.
You said that this is an exculpatory statement.
Yes. Exculpatory, Lordship, very interesting proposition of criminal law comes into play here, Lordship. The inculpatory will be governed by 164, it will be a confessional statement. Lordship. And so I have got a two spectrum of arguments starting from here. The first would be inculpatory. That means I've already gotten evidence as prosecution. I've already gotten evidence, not from any other place, but from the mouth of the accused herself, as to what happened within the four walls of the room. So my first limb of argument, Lordship, would be I'll build up a spectrum. Inside, it's an admitted fact, she hit her husband, and she also hit the child.
164 confessional. That is one.
The inculpatory part is confessional.
Confessional in 164.
164.
Which does not require any
Lordship,
tendering as evidence.
It is a substantive piece of evidence, very, very important evidence, but definitely we'll have to look for some kind of corroborations too. And we have it. And Lordship, there are two arguments. So I'm just giving the proposition of what are my two arguments. First would be inculpatory, where I build up my circumstantial evidence. Second would be exculpatory.
No, what you meant to say, if I have understood correctly, is that if it is 164 and say the confession is ingrained in it, 164 statement,
Lordship.
and say the statement is in writing,
Lordship.
signed,
Lordship.
you don't need that procedure of a witness in the box
Absolutely.
proving that statement and tendering it as an exhibit.
Lordship.
You can, as a statement itself, under that provision of
Section 80.
just use it as evidence straight away.
Absolutely.
That is how I have understood. Rightly or wrongly, I do not know.
Then Lordship is correct. The second part which flew from your Lordship was how do we ascertain the veracity of the statement itself. That was taken care by 463 because the accused has got an opportunity under 315 to present herself as witness. Now she has waived their opportunity. The moment she has waived their opportunity, Your Lordship, the statement also becomes admissible. So the facts of confessional statement, that means the inculpatory part, has been proved by the prosecution. So the Lordship, these are two propositions. The second proposition is the exculpatory part. Now that will be governed under the law, Lordship, that will be governed under section 12 of the Evidence Act. That will not come within the meaning of confession, but that will be admission. So that will be, that is where the second limb of my argument, Lordship, as a prosecution, I'll try to say how we can prove the case using both the spectrum. So first I'll just confine to the confessional part and the inculpatory part. Then I'll come to the second part, Your Lordship. But sure, I will not repeat it again because her confession is regarding killing of a husband and the child. Now, the court will see if this is the statement which is admissible under section 680 and 463. What are the other evidence that corroborate this? Lordship, first we will go to the statement of PW2. Page 62, Lordship. The circumstances within the place of occurrence has been proved by the accused herself by. Now what happens what is the next circumstances and who witnesses it? That means what happened when she came out from the door. So this is very important, Your Lordship. PW2 is the first eyewitness, page 62, Your Lordship. Please, Your Lordship, if I may just read the relevant part. I do not remember the date of the incident, but I remember that on that day, I was washing clothes in the morning in public tap, which is near the house of deceased. And while I was washing the clothes, I suddenly heard the screaming of deceased. Actually, very important is the screaming of deceased. First thing that this witness hears is the screaming of the deceased. And when I look, I saw the deceased coming out of the house. Hearing the screaming, and second, seeing. He's an eyewitness. We saw the deceased coming out of his house and went and collapsed just outside his house. So when he heard and when he saw deceased was alive, he was running out of this house and he saw him collapsing. Then I saw the accused, so-and-so, wife of so-and-so, deceased, coming out of her house, holding dao in her hands and gesturing and threatening with the dao. The first circumstances, what happened after the confession. As I submitted, Your Lordship, the confession needs the chain to be completed, and the chain has to be fully.
Here the examination in chief, cross-examination is not recorded.
Decline, Your Lordship. Decline. Lordship will see in the same page. Shri so-and-so advocate for the accused decline. They chose not to cross, Lordship. So this stands proved, basically. So the first corroboration of what happened inside and what did the accused do after. This witness sees, he knows the deceased and he hears him, and then he sees the deceased coming out.
You were not there before the trial judge.
No.
Then he has.
We were very lucky, Lordship. Senior counsel was not.
I was not there.
He has killed your case.
Persecuted the defense.
No, let him submit. I'll come into the place. I'll do what almost.
I think that's all, Mr. Khan. What else you will submit? You want to show some cases?
The cases are there, but Lordship, the same thing happens with PW1, PW2, PW3. Basically, Lordship, this issue has been addressed in para 41. Now, PW1, PW2, PW1, 2 and 5 are eyewitness, Lordship.
You see, this all forms a chain,
Lordship,
which it is also called res geste.
Under section 6 of the evidence,
Yes.
that is an exception to hearsay evidence.
Yes.
Res geste is an exception.
One of the exceptions.
One of the exceptions under section 6, section 6 Lordship. Now, Lordship, all this change, that means the confession of the accused statement also finds corroborations and form a chain which clearly proves with the consistency that the accused have committed the offence. It is not inconsistent with the innocence, rather it is consistent. This is the principle of circumstances. It is consistent with the guilt of the accused, not inconsistent with the innocent. 3 eyewitnesses, Your Lordship, 1, 3 and Lordship can kindly note it, 1, 2 and 3 are the eyewitnesses who have completed the chain as to what happens after the door, outside the door. Now, Your Lordship, the second would be, Lordship would ask me, then what happened when the body was collapsed? What happened? That is where the investigation comes in and the inquest report comes in. The injury is stated in the inquest report, Lordship, which is at page 54. So, another chain completing. Now, inquest is very important, Your Lordship, because that needs to be corroborated with post-mortem. The post-mortem report also corroborates. So 164 statement first finds corroboration by an eyewitness. It also finds corroboration by an inquest report.
You see, it's like this. I heard the deceased screaming.
Right.
Isolated, it means nothing.
Nothing.
And then I saw the deceased coming out of the house.
Correct.
Nothing. Collapsed just outside his house. Maybe suggestive of something.
Something.
And then I saw the accused, wife or son, coming out of her house holding a dao. That is also nothing. You can come out with a dao to cut a coconut.
Absolutely.
All right. Then gesturing and threatening with the dao. Now a combination of all
this, yes,
will be the necessary evidence.
And Lordship, had it been only PW2, yes, but then the same version has been stated by PW1 and 5. So there are 3 eyewitnesses corroborating as to what has happened. Now this finds credence, Your Lordship, when a confessional statement says she hit it. When you see that the chain is complete. Chain is complete only on the first part as to what happened inside and what happened outside. Her statement that she had killed her husband and a child are corroborated by the eyewitnesses. So the first major chain link is complete. And then the body part and the post-mortem part. Inquest is very important in Lordship. The inquest is very, very important in a murder cases. Why? Because that's exactly how was the body located and what was the injury mark. To eliminate any possibility of tampering. That corroborates with what happened. And for further credibility of the inquest report, there has to be no contradiction in the post-mortem. That will give a benefit of doubt. That is also corroborated.
We'll continue tomorrow, Mr. Khan.
Tomorrow it's a holiday.
Oh yes,
Friday.
day after tomorrow. Is there any system of verification of a post-mortem report?
Lordship.
Now suppose if in a post-mortem the government hospital says that this was the cause of death. Now say the accused, potential accused, thinks that the report is wrong. Does he have any...
Lordship, if I may submit, you need a very, very skillful defense lawyer to create a doubt into cause of timing, death. The timing, in Lordship.
No, but you can't get the report re-verified like...
No.
Like you get your blood tested, then you say that I want a retest of my blood.
Lordship, if I may just submit, that's why I said this is itself a very important jurisprudence in criminal law. The timing of inquest is very important.
Yes.
If the inquest timing is supposing at 12 o'clock in the morning, Lordship, 12 o'clock in the morning, inquest was done, means the body was found on the PO. Post-mortem is done at 9. The challenge before the doctor is to lay down as to what was the cause of death and at what stage the body will suffer from rigor mortis. If there is a gap in that, then that benefit of doubt will always be given to the... Because doctor's post-mortem report is never conclusive, Lordship. It's tentative and probable. So the timing of inquest and this, there has to be a match. And then the cause of that, the time gap is very, very crucial.
No, but is that report taken as sacrosanct? It cannot be challenged.
No, Lordship. They depends upon the defense lawyer.
Poison is found in the stomach.
Lordship, yes.
The accused thinks it is not poison. It is a wrong report.
Then the Lordship, FSL report becomes very important. FSL will report about the food consumption and the finding, whether it was out of fermentation, whether the food was taken by him or whether he consumed it by mistake. Now imagine a situation, Lordship, if a person dies in a room, he consumes a stale food and he is staying with a friend. Now the allegation would be in a friend of having murdered him.
The accused have a right of seeking a fresh post-mortem or is one post-mortem final?
Lordship, in a situation which is very glaring, where a doctor has not done his required responsibility and it touches the merit of the case, maybe in such situation a retrial can be done. Retrial can be done.
All right.
It can be even for examination of the body also there. It can be.
Sir. Additional Advocate General, Mr. Khan, continues his argument but does not conclude the same. This appeal is to retain its position in the list to hear further argument.
Lordship, Friday? Tomorrow is a holiday.
Friday?
I won't take much time, Lordship. If Lordship is satisfied with the change circumstances, Lordship, I'll hardly take...
See, my experience in criminal matters is very limited. Is absolutely negligible. So
Lordship,
it is a very valuable assistance to you.
And Lordship, if I may just submit that exculpatory part, is a classical case of sui generis, so far this case is concerned. Very, very unique where you have somebody saying something else and implicating and also saying I'm not involved. There, Your Lordship, the exculpatory part, we'll have to take the route of section 106. So it's a very unique thing. I'll just try to assess the court.
We have dealt in criminal matters in a limited way when we went to circuit in Andaman or during the COVID period or during the vacation bench. That's all. So lot of assistance from you and will be required in this matter.
And I'll also try to assist Your Lordship what is submits that part.
Why learned senior friend, Your Lordship, he's a legend of the bar and so for criminal matters is concerned.
No, it's not.
We have seen him, we have grown with him. It was really an honor sometimes. So that's why I'm more than required trying to be persuasive.
That is why he has been engaged where
Yes.
cross-examination has been declined.
Yes. I can imagine if he had done the cross-examination.
Thank you.
Much.
Obliged.